Good afternoon. I know we've been learning a great deal from the panels. Before we move on to the next panel, it's a real honor to introduce the keynote speaker at our conference, Chief Judge Randall R of the Court of Appeals for the Federal Circuit. The Court of Appeals for the Federal Circuit is the U.S. appellate court that has exclusive jurisdiction over patent cases. Chief Judge Rader was appointed to the U.S. Court of Appeals for the Federal Circuit by President George H.W. Bush in 1990, and he assumed the duties of Chief Judge on June 1st, 2010. Chief Judge Rader has led dozens of government and educational delegations to every continent, except, I am told, Antarctica. And I suspect, having spoken to Judge Rader for a few moments before this introduction, that he will get to Antarctica. He has taught rule of law and intellectual property courses in his travels. Due to the size of the courses he has taught and the diversity of those classes, I think it's fair to say that Chief Judge Rader has probably taught more patent law students than anyone else, maybe in the world, but certainly in the United States. Chief Judge Rader has also co-authored several texts, including the most widely used text on United States patent law. Judge Rader has received many awards, including the Sedona Lifetime Achievement Award for Intellectual Property Law in 2009, the Distinguished Teaching Award from George Washington University Law School in both 2008 and 2003, which is elected by the students, and the Jefferson Medal from the New Jersey Intellectual Property Association in 2003. I'm also very excited to let you know that Chief Judge Rader has agreed to be an honorary advisor to Stanford's China Guiding Cases project. So thank you very much, Chief Judge Rader, not just for being here, but also for supporting that important project. I now want to recognize Dean Zheng and ask him to come to the podium, and then we'll hear from the judge.
这个接着院长的这个刚才的介绍，我再补充一点点。那么瑞德法官呢，去年10月23号专程去访问北京大学法学院，在北大期间呢，北大的校务委员会的主任朱山路教授，也就是中国的这个北大的这个党委书记，就是最高的领导了。然后还有现任的校长，就是新任的校长王恩歌教授院士，那么一起呢亲切地接见了这个雷德法官。当时呢，我也在场，因此呢，其实我们是老朋友。第二天呢，这个在北大呢举行了一个知识产权和反倾销方面的这样的一个论坛。这个雷德法官呢，在这个会上做了一个非常精彩的这样一个演讲，与会者呢都觉得呢收获颇丰非常的大。所以的话呢，我觉得是非常好。那么今天呢，这个院长这个把雷德教授雷德刚才讲了，你得了那么多的奖，写了那么多的教科书有那么多的学生，中国讲叫桃李满天下，所以我觉得非常难得。因此呢，今天我想与会者呢听你再做一个精彩的致辞，一定会收获更大。我简单的就补充这么多，谢谢大家。
谢谢。I don't like podiums. Last year, a very historic event happened when the United States Court of Appeals for the Federal Circuit went to Beijing and held a joint judicial conference with the IP division of the Supreme People's Court. So many of my dear friends from China are here today, and I'm very happy to see the dean amongst them. It's interesting that before I went to China, a senator called me from the Judiciary Committee. Now, before I was a judge, I worked for the U.S. Senate. I actually had worked with this senator, but he was quite concerned about my decision to take my court to China. He felt that United States courts should be administering United States law and have little to do with foreign courts. I welcomed his call and I went to his office. Now, I will be honest and tell you that when he asked me the obvious question about why I was taking my court to Beijing, I gave him a very political answer. I will tell you that political answer, but I want you to understand that I think the real answer is something else. The political answer I gave him was that, of course, intellectual property is critical to the economy of the United States. And if we can cooperate with foreign judiciaries in learning to better enforce intellectual property, it will help the United States economy and United States jobs and his constituents. This is politics. And I apologize to this audience for that answer. As I say, I had worked there for many years, so I knew the kind of answers you have to give. Let me tell you the real answer, as I perceive it. The real reason that the United States judiciary needs to meet with the Chinese judiciary is because our two nations are the economic leaders of the next century. And that leadership requires of both of us great responsibility. We must learn from each other and cooperate with each other to fulfill the responsibilities of that leadership. I'm going to spend much of the rest of the time with you talking about what I think that leadership requires of us. But before I do that, I want to take just 1 second and tell you what a marvelous experience my court had with the Supreme People's Court in Beijing. We were, of course, very impressed to arrive on the campus of Renmin University. I'm sorry, my dear colleague. I'm actually a professor on Beidah's, an honorary professor at Beidah, but this conference was held at Renmin. I apologize. We must have another one at Beidah. 1,500 people were in attendance. 300 judges from throughout China. And we did learn from each other. Now, let me be very direct and honest about something. I think the United States has as much to learn from China as China can learn from us. We really do have some very significant problems in our litigation system. The Chinese system is less expensive, more efficient. We need to learn that. And so I am quite sincere in my professed goal of cooperating which is a two-way communication with the judges in China. Now let me go back to our leadership in the world economy and the responsibilities I feel that that gives us. There is both of our economies have profited so greatly from the intellectual property system. And yet that system has come under attack, and that attack is partially due to abuses within the system. And that's happening in China as well as in the United States. I think our leadership in economic affairs in the world is going to require us to focus efforts on improving, preserving, and strengthening the intellectual property system, which has brought such great benefits to both our nations. Let me first be a little more specific about the concerns about the system. The patent system has been under attack in the United States because it is seen as causing a great deal of litigation, which is expensive and difficult for corporations and companies to handle. Let me state right up front that there is a great problem in this area, but it is not a problem with the patent system. It's a problem with our litigation system. Unfortunately, many of the scholars and politicians who have dealt with this problem have instead focused their efforts on reforming patent law. They think if they can reform patent law, that will have some long-term beneficial effect. This misses the goals of the patent system and fails to recognize its limited role in our economies and societies. I wish I could spend a great deal of time talking to you about this, but let me try and say concisely, the patent system is not a consumer protection system. It is not a system to regulate prices. It's particularly not a system that has anything to do with health care distribution and this aspect of consumer protection. Can I share with you my favorite demonstrative fact on this point? The World Health Organization of the United Nations has a list of 300 essential drugs. These are essential treatments for human well-being and health. How many of those 300 are under patent, are now currently patented drugs? Oh, you think you're just supposed to sit there and listen, don't you? No, you have to answer my question now. What's your guess? Somebody guess. 200 out of 300. Thanks. There's one guess. Somebody think that's too high, too low? Yeah, too high. What do you think? 50. 200, 50. 100. 300. Somebody's got 300. Have you heard me speak before? The answer is 3. Now, you would think, with all the concern about patented drugs having some effect on health care, that it would be a very large number, 250. It's 3. Let me tell you one other fact, though. Guess how many once were patented? 298. Which gives a quick lesson if you think about it. The patent system is essential to provide us treatments. And we have many treatments that we still need. We have not cured AIDS or cancer. And there are human ailments far beyond those as well. We have much yet to invent, much yet to accomplish to solve human problems. But notice, the patent system is not causing problem in the healthcare distribution area. It's not regulating the prices of those, all but 3 of those drugs. But it is providing us with those drugs. And by the way, that is the sole narrow purpose of patent law. We have in the United States a document now that's about 230 years old that explains quite succinctly the purpose of patent law. It is to promote the progress of science and the useful arts. That's all. Patent law doesn't regulate competition. It doesn't affect healthcare distribution systems or consumer fairness, or it simply creates for us new technology. Unfortunately, the system gets attacked because for things it's not supposed to do. It's just supposed to get us new technology, and it does that, by the way, in a couple ways. First, it, of course, protects the investments in research and development. Many of those investments happen at universities, which are very important in the field of patent law. But it also has an equally important function after the patent issues of providing incentives and tools to make sure that the technology is converted into use, that it becomes a used art as well as useful art, that we actually use the technology. But once again, it really doesn't regulate many of the affairs for which it's criticized. Let me tell you one of my quick favorite stories. I was in India. It's been about, I'm afraid it's more than 10 years, which is what's bothering me. It's been a long time ago. If you've ever been to India, they have at this kind of a conference, they have a very beautiful ceremony. If we were in India, there would be a large lamp sitting here beside the podium. It would have basins of oil, and there would be wicks hanging over the edge of the lamp. the sponsor of the conference, Dean, that probably would have been you, would start the conference by lighting a candle and lighting one of those wicks, and then she would hand the candle to the next speaker, and they would light another. A beautiful symbolic spreading of light, which is what a academic conference is supposed to do. Well, I was at one of those ceremonies, sponsored by a deputy minister within the Indian government, and he lit the first, and I lit the second of these, and as we are standing then waiting for 20 or 30 more lightings of this lamp, the minister leans over to me and says, "Judge Rader, we are in India. India is a compassionate nation. If you can't describe the patent system in compassionate terms, perhaps you shouldn't speak at all." Okay, if I made you speak about compassion in the patent system, how would you do? And I had about 2 minutes to come up with compassion in the system. Here's what I said, and I'll update it a bit. It's now 2013. That means every invention after 1993 is every invention before 1993. Everything that happened before then is absolutely free to every person in this audience. You didn't pay a penny for it. Think of all the treatments. I just learned in Leuven, Belgium, where they invented the key AIDS treatment, that was done before 1993. It was done in the mid-'80s. So that, amongst all of the other things, is free to you. You didn't pay a penny for it. Now, your parents did. Your parents paid a little higher price for products throughout their life to give us inventions like the treatment for AIDS, the advances in computer technology, the advances in communications and transportation. Just think of all the magnificent advances. Your parents paid a little more for those. And then they gave them to you as a free gift and asked only that you do the same for their grandchildren. That's really what the patent system is. It's a generational gift-giving system. We each add a little capital. We pay a little more for the products that are patented in order to create a fund for research and development and to drive forward new technology, which we will then give as a free gift to our children. That is what the patent system is, a great generational gift-giving system. And therefore, very compassionate. How'd I do? You know, the minister, he got, they had an election. Those are sometimes unfortunate. You don't always win those. And so he's no longer the minister. His party lost. And so you can tell how long ago it was. I think that's at least 7 years ago, isn't it? But he's now the head of the Institute for India Technology in Bombay, and he invites me back every year or two, and whenever we're having that lighting ceremony, he'll always lean over to me and he'll say, Judge Rader, do that gift thing again. I like the gift thing. But I think that focuses us on the responsibility our nations have to protect the strength that the patent system provides in giving us new technology. I have been amused to see the public press criticism that follows large cases that happen in the field of patent law. And the big one at the moment is the Apple-Samsung dispute that has sprung up around the world. And they talk about in the press always, oh, this is going to restrict consumer choices and raise prices. That should cause you to chuckle, because I can go down to a store within a mile of here. There's one within a mile of anywhere in the United States, and I can walk in and there will be 300 different phones on the wall. Restrict consumer choices? They will have 50 different ways to pay for them, including some you can get for free. Now you have to accept a monthly service charge for Verizon or AT&T or somebody. But consumer choices and market alternatives in this field are enormous. It just strikes me as out of touch with reality. Well, let me go on to, my time's getting away, isn't it, Dean? I'll finish up and then you can ask me some questions. But let me tell you where the problem lies, because there is a problem. There's a problem of abusive litigation. And now you're saying, oh, he's going to talk about trolls. For our Chinese guests, I think you've even become familiar with that term if you've been here long enough. There's nothing wrong with entities that buy and even assert patents. That's like any entity in a commercial system that buys and circulates property. We have realtors that do that with real property here in the United States. But there is a problem at the heart of the system. It isn't in trying to identify who is a good or bad user of intellectual property. The error comes in the improper assertion of the value of that property. And this is a rampant failure, at least in the US system, and the Chinese system must be careful to avoid this. That is that a patent gets asserted far beyond its contribution to the field of art where it has improved. There can be many kinds of improvements in a field of art. Some of them can be very small and have very tiny value. That means they deserve only tiny value, and yet they get asserted by, and I would observe that I do see certain kinds of entities do this much more often than others. But it doesn't really help me as a judge to try and define their characteristics and punish them based on characteristics. We don't do that in the law. You don't decide cases based on characteristics of the parties. A corporation doesn't lose just because it's big or small, because it's from Uganda or from Canada. The nationality, whatever the characteristic of the party, that's irrelevant to a legal dispute in a court. What is relevant is when they assert property far beyond its value and try and say that it has a vast value, and then it becomes almost a blackmail because of the expense of litigating this dispute to closure. Often they can induce parties to settle for less than the cost of litigation. Well, that tells us our litigation system costs too much. Those of you who know me well know that I'm working hard on that, trying to reduce the cost of discovery, reduce the number of issues that can be asserted in an intellectual property suit, require accurate and early valuation of the patent being asserted. And if that has been asserted far beyond its true value, then we need to reverse fees and punish, not because of the characteristics of a party, but because of the way they have acted in the court, asserting that property beyond its value, and thus jeopardizing the contributions of the patent system to both of our economies. Now, as I've suggested to you, the public press doesn't pick up on the nuances of litigation abuse. They like to just say, oh, the patent system's broken, and it's restricting consumer choices and raising prices. I hope I've suggested to you that you should view that popular press with a good deal of skepticism. And then I invite my dear friends in the Chinese judiciary to continue to work with me and my magnificent colleagues in reducing the cost of litigation and making the system continue to perform as it has, as a great generational gift-giving system. 谢谢. How'd I do? Dean, was it?
We have about 5 minutes.
Judge
Rader has said he would take some questions, and we have about 5 minutes.
Anybody want to ask me a question? I put you all to sleep. Professor Chen, this is not going to be an easy question.
Thank you. That was a great speech. And I was wondering if you could answer your own question about what you think the U.S. court system can learn from China from your travels. Is there anything in particular that you think is something you've taken into your own practice, or do you think?
Thank you. No, that's a great question. A dispute in China lasts generally months, whereas in my country they often last for years. They very often come to a closure based on let me say quickly, I have such great admiration for the Chinese judiciary, more than Ron would agree with me. Ron, Judge White, my dear friend, is here in the room. He and I have been to China together a couple times. And we can go in and sit down with a Chinese judge and within 20 seconds be discussing enablement or injunction policy or in the fine points of legal reasoning. The Chinese judges know the law and know it well. There's my dear friend, Judge Kong, and I'm sure he's responsible for leading his judges to be so proficient. But we need to learn how to reach decisions in months rather than years without spending $3 to $5 million in discovery expenses. Thank you. Actually, that wasn't so hard. Judge Chen, she's usually tougher on me. Well, Dean, I guess we... please.
How about time for one more question?
The question is, what do you think of the lack of punitive damage under the Chinese bank law system?
What do I think of the lack of punitive damages under the Chinese system? There is a limited role for punitive damages in the U.S. system. And I don't think I have awarded any punitive damages in an intellectual property case for probably 5 or 10 years. So I think a system can work quite well without punitive damages. It is, however, a good tool to have in that rare case where someone really does deliberately flaunt the court system and continue to infringe past an order to stop. Thanks. Thank you, everybody. I enjoyed this.
Well, I know on behalf of Dean Zheng, and I want to say thank you so much, Judge, for being with us today.
Thank you.
I think